Alright, so this is Judicial We the People News. Alright, this video is without prejudice and or without recourse. I'm not an attorney. I am not giving legal advice, okay? Neither is this video. It's just a learning video. And do not take it as such as any type of legal advice, okay? It's also opinions, okay? Never, never, never look just straight forward. Always look around you. Be all around you to be able to protect yourself by any means necessary, y'all. Alright, so I've already explained this to other people, but since I have newcomers, I'm not scripted, y'all. I don't have time to write scripts. Okay, so anything I do, maybe just fumbling of the mouth or just state of pause or whatever, that's because I don't sit and study on a particular video. Okay, or anything like that, or script everything out. Okay, we talked about notice of liability. Alright, and this is a mirror of of my videos a couple of years ago of notice of liability. When I talked about notice of liability before, well, this is a different version of it, but once again, it's still a notice of liability, and this is, you know, how notice of liability can be changed by so much and still have the same benefits. Okay? And yes, up on that corner there, if it clears out, it says notice of liability non-judicial. Okay? It's private court. When it's non-judicial, it's private court. When people say there is no such thing as private court, there is, y'all. How do we access it is a question, right? Alright, this is another take from the other one we did. Okay?
So, if you go on the website, empowermovement.com, you can download the template, which is the notice of liability. And it's a fill-in template, so you can just fill it in and then mail it off. And it has everything you need. You can add more people to the liability list and make changes if you want. But his position is just that the template has to be used the way it is if you want his help in making sure you get what you want out of the situation. Most people's processes are really only perfected if you do it exactly the way they have it written. And, you know, if you're competent to modify them, then, you know, you can do whatever you want, but you're also responsible for doing whatever you want. So in this case, you're going to find out the people that are acting as the power supply company, the PUC, the Public Utilities Commission, the legislators that helped enact this stuff, and they're going to be the people that are going to be.
Alright. I didn't do it last video, and I'm going to do it this video, right? Notice a couple of keywords. Nunc pro tunc. Okay. He's actually going to give the definition, so I do not have to. Alright? Share juris. Okay?
The recipients of your libel. They're going to be the liabilities. So he calls hereinafter respondent liabilities. They're going to be the ones that are liable for the damages that they're causing you by the installation of the smart grid and the smart meter. So he starts it off with a preamble, whereas it appears this and it appears that, and the only people that I know that do statements like this, whereas, are legislators. Most of the bills that you see are, you know, whereas the Bible is the Word of God. So anyway, he starts off with a bunch of whereas statements, and then he moves down to describing the restrictions that this contract are going to place on you. So the restriction of jurisdiction, other than as expressly represented herein, you agree that no section of the contract shall be assumed to constitute a voluntary election by any of the parties thereto to submit the contract or the said parties to any venue of law, jurisdiction, court, or tribunal, other than by the agreement of the parties as stated hereunder. So you basically are telling the other party that they are not going to be able to take you to court on this, and a document will not be able to be reviewed by an agency or administrative tribunal or any court subject to the federal or state or political subdivision. So you're keeping the contract away from the purview of any other man, right? Basically, it's a deal between you and the people that you're sending it to. And when they sent you an offer, it was a deal between them and you. They didn't say, "Oh, you can take this to court." No, they just sent you a notice in the mail and said, "This is what's going to happen." And so this is just a counteroffer saying that, okay, I accept your offer based on this, and if you don't like it, you can remove your offer. And if you don't do anything, then you're going to be all bound up forever, because I'm going to tell you exactly what's going to happen to you if you don't rebut this. So we have the definition of contract from Black's Law, just so you know what a contract should be. An agreement between two or more parties, preliminary step in making of which is offered by one and acceptance by the other, in which minds of the parties meet and concur in the understanding of terms. And second, it is an agreement creating obligation in which there must be competent parties, subject matter, legal consideration, mutuality of agreement, and mutuality of obligation. An agreement must not be so vague or uncertain that terms are not ascertainable. So when you have a meeting of the minds, two parties that get together and bargain for something, they have to understand exactly what the bargain is for, right? Everything has to be spelled out so both parties are happy. If you think that you're buying something and the other person thinks they're selling something, but the thing that one person is selling and the other is buying are different things, then obviously you didn't have a meeting of the minds. And can you have two competent parties if one of the parties doesn't exist? That's the problem with all contracts. The state would have you believe are contracts, like a driver's license. A contract where there's two competent parties. How competent can the state of California be? I mean, they don't exist. They can't perform. They can't have an obligation that they can perform on. How are you going to have mutuality of obligation or agreement? How can there be an acceptance if the party that's doing the acceptance isn't real and doesn't exist? How is the party that doesn't exist going to have a meeting of the minds when it has no mind? So that's what a contract is supposed to be. And if you were buying lumber at the lumber yard, that's what the contract would be. It's only in fiction world where the contract doesn't comport to that. So under Bouvier's Law Dictionary, under maxims of law, consent makes the law. A contract is a law between the parties which can acquire force only by consent. Now, it's not a law between you and anybody else. It's only a law between you and the other party who are engaging in the contract. The contract becomes enforceable between you two, not enforceable outside of the two parties making the agreement. And it acquires force by consent. But there's a lot of definitions for consent. They use the definitions for consent against people when they say that you can actually consent by not saying anything. So here's the next definition: tacit, done or made in silence, implied or indicated but not actually expressed. So there's no written or verbal expression. Latches, estoppel by, a failure to do something which should be done or to claim or enforce a right at a proper time. So time is an element for latches. A neglect to do something which one should do or to seek or enforce a right at a proper time. A species of equitable estoppel or estoppel in by matter and paes. So estoppel is a bar. you're being stopped from proceeding at a later date because you waived your rights. It's the same thing as saying you're barred from making any complaint. You had your chance to complain, and after a certain period of time, you were barred from making that objection. You let it go. So when you say you have 30...
That's what happens in family court, y'all. The judge is not telling you that they have a conflict of interest against you. However, you just say, okay, whatever. And you still tacitly agree to the judge and them attorneys having a contract against you. And they are allowed to say, well, he didn't say nothing, or she didn't say nothing, so we can go ahead and proceed forward in our conflict of interest to benefit us.
Days to respond. If you don't respond, you had your chance, and now you don't have it anymore. Neil he says nothing. This is the name of the judgment which must be taken as of course against a defendant who omits to plead or answer the plaintiff's declaration or complaint within the time limited. In some jurisdictions, it is otherwise known as judgment for want of a plea. So this is what happens in a court. If you put in a complaint in the Federal Rules of Civil Procedure, you have 21 days to answer. If you don't answer, the other party can get a default judgment. The default judgment is the most powerful judgment because there's no dispute. It's not like the jury's going to decide one person's facts are better than the other and they might have got it wrong. No, one party made the claim that you wronged me and the other party didn't object to it. They didn't put it in writing. They didn't say they didn't show a reason why they had a right to wrong you. So they defaulted on being able to make the claim. Acquiescence and lapses are cognate but not equivalent terms. The former is a submission to or resting satisfied with an existing state of things, while laches implies a neglect to do that which the party ought to do for his own benefit or protection. Hence, laches may be evidence of acquiescence. Laches imports a merely passive assent, while acquiescence implies active assent. Like, are you okay if I go dancing with your girlfriend? If you don't say anything, then that's an active assent. So he who is silent is supposed to consent. The silence of a party implies his consent. You don't say anything, you must be okay with it. You implied the consent. And then he who is silent is considering as assenting when his interest is at stake. So when you grab your friend's car keys and you go, hey, I'm taking your car, and you're looking right at him and he doesn't say anything, if his interest is at stake, hey man, you can't take my car, I need it, or whatever. If he doesn't say anything, he must be okay with it. So there's an active assent there.
Now, I want to just say right up front, the courts do use that, but that is Roman civil law maximum. Okay? So I don't even agree with this. And this is where they get ignorance is no excuse for the law. Right? Me, by looking at you with a grumpy face, that's automatically tells you it's a no. But the courts don't look at it that way, right? Because they're using Roman civil law against you.
Then silence can only be equated with fraud, where there is a legal or moral duty to speak. Now, morals are, domain of religions. Thou shalt not steal, thou shalt not bear false witness. These are morals. If you don't have any religion and you don't believe in God, you may not have any morals. Silence can only be equated with fraud. An inquiry left unanswered would be intentionally misleading. We cannot condone this shocking conduct by the IRS. Our revenue system is based upon the good faith of the taxpayers, and the taxpayers should be able to expect the same from government in its enforcement and collection activities. This sort of deception will not be tolerated, and if this is the routine, it should be corrected immediately. Like asking them a question and them refusing to answer. See, they have a legal and moral duty to speak. If you say, I deny that I'm...
Like the judges or cops, right? You ask them a question and they don't answer. What about the attorneys? Just saying. There's a couple of examples right there.
Liable, and I don't see any constitutional authority you have to place a liability on me, and this is why, and they don't answer that, then they're just, deceiving you by failing to state any cause that you have a liability.
Again, Roman civil law that we're using here, the courts are using.
So here we are with the notice of liability again. Guarantees and waivers of benefits. Guarantees for this instant action are the 1611 King James Bible, the coronation oath of Elizabeth Alexandra Mary Windsor, the United States Constitution, the Bill of Rights, constitutional oaths of office, the common law, the law merchant, the Uniform Commercial Code, and case law. The claimant liabilint does not claim any benefits of said guarantees. They're included because the public officials, through their oath of office, are limited by those guarantees. They're mandatory and
I have to pause that there for a second. Okay, we talked about deceiving us, right? Okay, Article 6, Title 4, Section 101, Oath of Office, that every government official has got to sign, and they have not done it. So they have taken other oaths, but they are supposed to take the constitutional oath first, alright? And then they could take other oaths. But if they do not take the Article 6 Constitution, then they are deceiving you that they actually are in office. So anyone that has not taken this Article 6 oath of office, they're deceiving you, as they call themselves a government entity. So you can actually put the Article 6 in any type of paperwork and call it being deceived, because you have not filled out or shown verifiable proof of the Article 6 oath of office, which means all the judges are not judges. All the presidents we've had in the past few years are not presidents. All the Congress members are not Congress. We literally do not have a president, Senate, Congress, judges. Our country's blank. Just saying.
prohibitory on the oath taker, the public official. And all corporate officers are bound by the same restrictions that the agents of government are bound by, because all corporations are created as franchises by governments. They don't create themselves. They ask the government for permission to be a corporation, which grants them limited liability, so the people involved can't be sued. All they're trying to do is duck out of being responsible by forming a corporation. That's all it is. And for that privilege, the government gives them a privilege, but they can't give them something that the government itself doesn't have. So here at this website, they show the importance of the 1611 King James Version of the Bible. That King James Version of 1611 is what the Queen of England takes an oath of office on. In the United States, from George Washington to Barack Obama, each president has taken an oath on the King James Bible from 1611.
Oh, just a reminder, this is 3 years ago, or plus, I can't remember how many, but it's been a couple of years for sure. So, yeah, Trump was taking this oath, and Biden just took this oath since then, from King James. I say oath, but it's not the oath of office. They just put their hands on the Bible.
So now we have the notice. Response must be by the effective date. This is on the notice of liability, which is 14 days from the postmark date of this contract. I wouldn't use 14 days. It's too quick. It's do unto others as you'd have others do unto you. I don't like getting large pieces of documents that I'm going to have to pour through and respond to, and 2 weeks is not enough time for me. A month is reasonable. Response must be to the...
I agree with him. However, if anybody ever tells me that I got 10 or 12 days, whatever they tell me, that's the exact same day I'm going to tell them. They're not going to get a guaranteed 30 days. What are they trying to force upon me? I'm going to, balance the books.
Postal locations of the two witnesses. Now here, this is a thing of beauty, because if you go to court, the court is the observer. They're just doing ministerial function. They're letting know the docket shows when the document got put in and if there was a response or not to that document. When you're using two notaries, or if you're using a notary, then the notary is going to be the honest person who's going to not be swayed by, and not an honorable person who's not going to lie for you. So they're going to say, I got a response, or I didn't get a response. But since you're not really trusted to not lie, if you have two people that aren't related to you, like, not your cousins or brothers or something like that, but two independent people, yeah, they're going to be a witness. And the definitive term is what the Bible declares. So I like to use the New Testament, so if I can. So here you have Matthew 18:16. But if you will not hear me, then take with thee one or two more, that in the mouth of two or three witnesses every word may be established. So that would be you and one more would be two witnesses, you and two more would be three witnesses. And, two witnesses that's not you would be able to establish the fact. Like, they say it happened, then it's not likely that they're going to be lying. So in order to find out the parties who you're going to send your notice of liability to, you're going to use the internet. It's pretty easy to do a search. And here's an example of searching for the members of the PUC, the Public Utilities Commission. If you keep looking, you end up finding what you're looking for, but you have to be pretty diligent about exhausting every little place that you can try to find things. Mostly you try to look for the contact us or about us section. But anyway, you look it up on the internet and keep searching until you find it. The other advice I'm going to give you is that when they give you a telephone number, oftentimes it's worthwhile calling them and ask the secretary or whoever answers if they have a fax number, an email account that you can email, the name of the person who's the CEO or the president, and the address, because maybe the address that they have on the website's not the current address that they're using, and if you don't have the right address, you're going to be mailing out your documents and they're just going to come back. And if they come back, well, then they didn't get them. The other thing you're going to want to do is, you notice how I highlighted the address and the telephone numbers and everything. You're going to create a Word document, just paste that information there, so when you want to go look for it later, it's easy to find. And then you can, just put all of the contact information and addresses and everything onto a Word document. And you can keep that Word document with make a folder up on your desktop that's notice of liability for the power company or whatever, and put your Word document in there. So you can see with a little more searching, I came to this page about the CPUC, and it's got Michael Picker, who happens to be the president, and it also lists the other four members. So you need to get their information, the true name. So you can click on their bios and read who they are, and you're going to click it, you're going to send the NOL, and I would send it to like 2, 3, whatever members of the PUC, because they're responsible. And if you keep searching, who appointed them? How did they get into power? You find out that Governor Jerry Brown appointed them. In addition to that, you're going to claim that they're acting as respondeat superiors. So it's a maxim of law. The respondeat superior is the person in charge, the person who's responsible. If an agent acts and does something according to the wishes or policy of his superior, then the superior is responsible for his actions. That's the concept.
So if you go after a judge, y'all, you go after you add the judge in there, but you also add the, what do they call it? Darn it. She's, the big judge. I can't believe I blanked
Of
on it.
course, if you go down to the bottom, you're going to say the doctrine does not apply in relation between state officers and their subordinates. Why not? Because the guy at the top wants to have no responsibility whatsoever.
Chief judge. All right. So you add the chief judge in there as well as the judge you are going after. All right. That way there is no place to run. And you can even go so much as the Texas Supreme Courts and then the Fifth Circuit Supreme Courts as my area.
But of course, his agent is doing, acts according to his policy, so he is responsible. So I've put in there that you're the respondeat superior. Another good thing to do is search the internet for information on smart meters. So here we have a ruling denying Marin jurisdiction to ban smart meters.
Okay, and this is just for y'all, it's just a go-by thing, right? So these are going after meters, but as you notice liability can be used for all kinds of different things. They just have a particular going after meters on this one.
And is that really the way it is? Well, no. If you look up Fred Kelly Grant on YouTube and his articles on coordination, if the local jurisdiction decides to enact an ordinance that smart meters are going to be banned, the state government and the federal government has to coordinate with them. And coordination means they have to obey them. They have to take the locals' rulings about what is going to be okay or not okay for acts within the geographical area that they have legislative authority over, and they have to abide by that. Look up Fred Kelly Grant coordination, and you'll see that the state has no power to overrule a local jurisdiction. So here's a little quick search for PG&E Corporation officers. You see that Geisha Williams, now I always like to get their full name, so upon a search I found that her middle name was Jimenez. Okay, so you use her full name if you can. And she's the president, and the rest of them are directors. So interesting, you're going to use at least 2, 3, you can put everybody in there if you want. But you're going to serve your process on these people because they're the ones in charge. They're the directors. They're the president. They're the CEO. They're the chief financial officer. So then we go on the Secretary of State's website. We look up Pacific Gas and Electric, and we call it. It's the corporate name, and we do a search for their business because if they're a corporation doing business in the state, they have to have the authority of the state say that they can do business, and so they'll list them in there. And when you click on the name, you'll find that they have a registered agent for service and process. This is a person who, because the business is a fiction, they need to have somebody that you can mail legal documents to. So I generally tend to go, okay, I'm going to send it to the person care of the corporation, care of the registered agent for service of process. And even though this is not technically service of process, at least they wouldn't be able to argue that you never properly served them because you did. And then when you look at all of their little filings here, it's kind of interesting. And here, let's look at PG&E, which is a publicly supported monopoly, because that's what it is, a monopoly. They gave PG&E the right to put their products on government-owned roads through easements and supply electricity for the benefit of the people. And the PUC was there to control them and say what they could charge and what they couldn't charge. But let's just look at the amount of money these guys are making. It's unbelievable. So this document shown here is filed by the state of California, by PG&E with the state of California on May 24th, 2017, and it shows what they were paid last year, these executive officers and directors. Anthony Early was paid $11,730,000. That's not bad for a year, huh? He's got 137,000 shares of a publicly supported monopoly. PG&E is a monopoly. They had easements to put their product on the streets that were given to them, no doubt, for free. How about all these other people? Jason Wells, over $3 million. Edward Halpin, almost $3 million. John Simon, almost $3 million. Hoon Park, almost $3 million. Dinar Mystery.
Please take a look at these images. Which person?
Anyway, there you go. Another outtake of the notice liability. We've seen that one, and then we've seen this one. This is how important and how diverse notice of liability is. Okay? There you go, people. Alright, Diesel with People News. Bye, y'all.